The learned First Appellate Court took up each of the issues based upon the contentions so raised by the learned counsels for the appellants and the respondents before the appellate court, and came to the finding that the learned trial court was justified in partly decreeing the suit for which no interference was required to the said impugned judgment and decree passed by the trial court. Full stop. It may be relevant herein to take into account that while deciding the issue number 5, which is most contentious issue, the First Appellate Court came to a finding that the plea taken by the defendants in their written statement that they had purchased 3 kathas 1 chatka of land out of the sweet land of Dag number 157 from the legal heirs of late Pochan Mia has not been proved by any oral or documentary evidence, and as such the stand taken by the defendants could not be established. Full stop. The First Appellate Court also took into account that it was an admitted fact that the sweet patta and measuring 6 kathas 11 chatkas was divided into 3 parts after the death of late Akram Ali, of which the 2 sons and daughter owned and possessed the sweet land in the ratio of 2:1. That is, the 2 sons got 2/5 share each, that is 2 kathas 10 chatkas 16 gons, and while the daughter got 1/5 share, that is 1 katha 5 chatkas and 8 gons. The First Appellate Court took into consideration the effect of the order dated 1/6/2009 in case number 67, which was affirmed by the judgment dated 20/2/2010 in criminal revision number 74/2009, and came to a finding that the inquiry under section 145 CRPC is limited to the question as to who was in actual possession on the date of preliminary order, irrespective of the rights of the parties. Full stop. On the basis of the above, the First Appellate Court affirmed the judgment and decree passed by the trial court, hereby dismissing the appeal. Full stop. Feeling aggrieved, the defendant number 1 and 2 as appellant have preferred the instant appeal under section 100 of the code. Full stop. Before examining as to whether a substantial question of law is involved in the case and can be formulated, this court deems it proper to briefly refer to the scope of the second appeal, as also procedure for entertaining them as laid down under section 100 of the code. Full stop. It is clear from subsection 5 of section 100 that an appeal shall be heard only on questions formulated by the High Court under subsection 4 thereof. Full stop. The expression appeal has not been defined in the code. Full stop. Black's Law Dictionary defines an appeal as a proceeding undertaken to have a decision reconsidered by bringing it to a higher authority. Full stop. An appeal is thus a judicial examination by a higher court of a decision of a subordinate court to rectify any possible error in the order under appeal. Full stop. The law provides the remedy of appeal because of the recognition that those meaning the judicial tiers commit errors. Full stop. Order of the code provides for the procedure to the followed while deciding appeals from the appellant's decrees. It states that the rules of order 10 shall apply so as far as may be to appeals from appellate decree. Full stop. The word such as so far as may be or insofar as means as such or to be extent or to such extent. Full stop. The virtue of order. Rule number 1. The provisions of order XLI are applicable to second appeal as well, though not in their entirety, but to certain extent, having regard to the mandate contained in order 10. This court, while hearing a second appeal, has to follow the procedure contained in order 10 to the extent possible. Section 100 of the code provides for a right of second appeal by approaching a high court and invoking its aid and interposition to redress error of the subordinate court, subject to the limitation provided therein. Full stop. An appeal under Section 100 of the Code could be filed both against concurrent findings or divert findings of the